clear this up, but let me ask it this way.
Okay.
Did you go through your records to try to figure out how Greg McMichael was notified in 2014 that he had a deficiency in 2006 and 7 and those other years? Once Post in 2014 started going through old records and discovered this, were you able to find any letter, email, phone record that told us exactly the date someone from Post notified Greg McMichael of those deficiencies in 2014?
What I have here is an email from Mark Melton to Jackie Johnson titled Post Notification that refers to speaking to Mitch Jones on April the 11th of 2014. Said he advised me and I confirmed by reviewing the training records of Greg McMichael that Greg is deficient in training hours for the years of 2005, 6, 7, 9, and 10.
All right, so
That's
that's the
only,
I'm sorry, go
I'm
ahead.
sorry,
Go ahead.
that's the only thing I have in that line.
All right, so the only thing that the Post records have is not any notices from Post to Greg in 2006, 2007, 2008, 2009, 10, 11, 12, 13. No notices to Greg McMichael from Post in those years saying, buddy, you are deficient. But the first notification you see is Greg McMichael having advised his boss, Jackie Johnson, that he received some notice that he's deficient in his training.
That is correct, and that would probably be the way it was back then because, again, you didn't have a system to track the training, so it would have come up as something perhaps, and I don't know what the exact cause was. Maybe Mr. McMichael was trying a new C11, going to work with another agency or something that put him on the radar here, so when whoever looked at his records saw the deficiency and would notify him.
All right. And would you agree with me that if Mr. McMichael had received a notification from Post and just ignored it, blew it off, that the likelihood of him being granted a waiver for those hours is almost unthinkable?
Yeah, the Post Council, which I'm a member of the staff, the voting members of the Post Council take the training very seriously. Training deficiencies, especially early on, were frowned upon dramatically. So if he had blown it off, not made any attempt to correct the situation, I'm sure they would have reacted harshly.
And those decisions about waivers and giving a waiver are controlled by your regulations. In fact, Regulation 464-18.02. That's correct?
464-1802. I'm going to have to look up.
All right. Well, would you agree with me? I'm looking at it here, but that these are controlled by regulations. These are not just internal willy-nilly policies that can change from administrator to administrator. You agree it's regulation?
That is correct. There are Post rules which carry the weight of the law in the state.
And would you also agree with me that in order to get a waiver, you must have good cause shown that would enable Post to exercise their discretion to give an individual a waiver, meaning you've shown good cause, you also have the hours that you've taken after the fact that can be moved back and given you a waiver for your certification?
Yes, ma'am.
I have no more questions.
Anything from the staff? Briefly. Again, good morning, sir.
Good morning.
This is Jesse Evans. We spoke earlier. Can you see me at the podium?
Yes, sir.
Okay, great. So you inherited the directorship of Post, is that correct?
Yes, sir.
You do not know defendant Greg McMichaels personally or professionally?
No, sir.
The records that we're largely referring to were actually generated prior to you taking the helm, for lack of a better term, of Post. Is that accurate?
Yes, sir.
Who was your predecessor in terms of directorship at Post?
His name is Mitch Jones.
Great. And you had mentioned this, and I think it bears repeating, that training is taken extremely seriously by post. That is a state mandate, correct?
Yes, sir.
And the failure to get training leads to suspension, accurate?
Yes, sir. After 2012, it leads to suspension. Prior to 2012, we didn't suspend for that.
Okay. And there is a notification process in place, at least now, for letting people know about their post training, correct?
Yes, sir.
Do you happen to know what that notification process was prior to you taking the helm?
I mean, it's been pretty much the same since I've been here. I got here in 2014. The system was set up in 2012.
All right. I assume that there was some way of documenting and notifying people that they were deficient in their training even before the email system and the gateway that you've talked about. Is that correct?
That I can't speak to. Like I say, it probably have been seen a red flag from something where somebody would have said, hey, I don't think John Smith got his training. Can you check it? Maybe an agency would call. Or if, say, for instance, we're going to change jobs and we had to look you up to make sure your certification looks good, then our certification specialists are trained, first of all, to check for any training deficiencies a person may have.
Can you see the screen that I'm sharing with everyone now involving these records, and can you confirm that what I'm looking at here, which is the state's exhibit involving the records, you've seen this stuff? I sent this to you.
Yes, sir.
And at the top of these records from June of 2014, there is a letter from the district attorney for the Brunswick Judicial Circuit to post, correct?
Yes, sir.
And can you see this portion here, starting with, this situation has been a great embarrassment to me and to this office. It has impacted the office.
Excuse me, Your Honor, that's not reading it. It says, this situation has been a great embarrassment to me and to Investigator McMichael, not to my office.
I'll continue on. It has negatively impacted my office, and I've taken measures to ensure this doesn't happen again. Do you see that?
Yes, sir.
This is page 13 of those records. Are you able to still see this screen capture?
Yes, sir.
This is a memo to file that was submitted to you. Do you recognize that as part of your post records? It's the 13th
Yes, sir.
page back. Okay. And referring to Greg McMichaels, he being the he, if you can see where my cursor is, he knew that he had been behind in his hours, but recently discovered he had no arrest powers since January of 2006. Do you see that?
Yes, sir.
And the date of this memo, can you confirm on the top line what that date is?
It says on Thursday, April 10th, 2014.
All right, so we're talking 2006 to 2014.
Yes, sir.
I'm going to scroll down to page 19. Do you,
I'm sorry. I thought I had the ringer turned off on this thing. It's just going crazy. I'll tell you what I'll do.
we can blame coronavirus. It's affecting everything.
Yeah. It won't ring now. Sorry about that.
All right, sir. Now I'll scroll down to 19. Do you see this email correspondence from the district attorney to Mark Melton, who I think you've identified as was he an investigator? Is that correct?
Yes, sir.
And specifically, I'm sorry, this is from Mark Melton to the district attorney. I think I misstated that. You see who the email correspondence is from and to?
Yes, sir.
Okay, and what's the date?
April April 15th, 2014.
And then this line that I'm highlighting here, can you confirm what the deficient hours were for Mr. McMichael?
Well, for multiple years, that's what the numbers in parentheses behind each year is referring to. In 2005, he missed 8. 2006 and 7, he missed, looks like all 20. 2009, he missed 17 hours. In 2010, he missed 1. Of these hours, it says it is mandated that the officer have firearms qualification and use of deadly force. So in that total of those hours that are missing, some of it was the firearms and the deadly force.
Use of deadly force training. And
Yes.
then go back to this first letter. What's the date of that letter from the district attorney asking for a waiver? Can you see the date at the top of this letter from the DA's office?
That says June 17th, 2014.
Okay.
And that looks like it's a thank you for helping with the waiver. So that would have been after the council meeting that granted the waiver.
Can you confirm, sir, that you can now see the rest of us in the courtroom?
Yes, sir.
All right. Judge, I believe that's all I have.
No more questions, may we release him?
Thank you, sir. You are released.
Thank you.
And with that, I'll hand it back to Mr. Rubin, and then we'll deal with any rebuttals to this after he does.
So we're back to the Travis McMichael's report call.
Yes, sir. Good morning, Your Honor. Your Honor, at this time, we would tender into evidence Defendant's Exhibit number 32. I believe I have the number correct. And that is a flash drive that I provided a copy of to Mr. Evans and Ms. Tonkowski, and I believe a copy to the court. I've renumbered some of the individual items to so that if the court wants to, we can go through it one by one. If Mr. Evans wants to, we can go through it one by one.
The state objects. This is the subject of a motion in limine that was filed and argued yesterday, involving, among other things, character of the victim and irrelevant evidence.
So I think we should go through it one by one. Because not all of it was ruled on yesterday by the court. That's fine. If I could just plug it in. I forget what Mr. Cedric told me yesterday. I checked that. Oh, there it is. Yes. So the court can see it and Mr. Evans can see it.
I made it fold. It was folded.
That one?
Nope.
Which folder? Okay. Yeah.
It's right there. It's this one right here.
Oh, there you go. There's that one. Okay.
Now, the missing step, if I can interject, I'm sorry, is you see the box that needs to be clicked. System, audio, that's it. That's the one I'm referring to.
I don't plan on playing any audio at this point, Your Honor.
If you don't do it, the judge is not going to be able to see it.
Oh.
That's simple as understanding.
Okay, so you just clicked on it, Mr. Hood, right?
I did, that is correct.
Oh. And then, where do I go from here?
You want your background for is that your phone?
can I assist to speed things along?
Absolutely.
If you'll click the left-hand box.
This one?
Yes, sir.
That.
Great.
No,
Well,
that's not mine.
I see it now.
If you, yes, sir.
Yeah. All right, there you go. Court can see that.
I can see that on the main one.
You remain, I'm sorry. All right, and the exhibit itself is 32, Travis McMichael 32. They're listed in with an A or A through Z and then double A through some double number, double letter. I'm going to skip around a little bit in compliance with the court's rulings yesterday. So I would start with number F, or letter F, which are the Satilla Shores Facebook page notes printed out.
Add some articulation of how that's relevant to obstruction, risk of flight, danger to the community, influencing witness, those kind of things, and 4 factors the court must consider, then I would say irrelevant and I object.
Okay. The second one is letters HH. It's a CAD detail report from July 13th, 2019. It's a call Greg McMichael made to the Glenn County Police regarding a person he suspected as being responsible for break-ins in Satilla Shores.
Again, irrelevant to the factors that this court must consider in this bond hearing, which are the 4 IAL factors. So that's a totally separate date, has nothing to do with even their client. This is Greg McMichael. How that impacts dangerousness, risk of obstruction, risk of flight, those types of things, I don't see how it's relevant.
Should we cancel all that up?
And it's all part of a continuing chain of events, so yes. The next one, Your Honor, is letter L, October 25th, 2019. It is a CAD report, a 911 call, and a transcript of the 911 call.
Same objection.
The next one, Your Honor, is letter M. This is the first one. L was a call by Larry English regarding a break-in into his home. M is also a call by Larry English on November 17th, 2019. 911 call, CAD report, and transcript.
Same objection.
Letter N is a call the very next day by Larry English, dated November 18th, 2019. CAD detail report, 911 call, and transcript.
Same objection. I can't see N, by the way.
You can't see it on the...
Not on my screen here, but anyway, same objection.
Let me just make sure so the court can see it. Can you see it now?
I see it on your screen. Yes, sir.
Okay. The next, Your Honor, is letter O. It is dated December 1st, 2019. It is a call by Larry English to Glenn County Police, also regarding suspect in break-ins, CAD detail report, transcript, and 911 call.
Same objection.
Next, Your Honor, is letters BB. B as in boy. It is a January 1st police report. That is the date of the incident in which Travis McMichael's truck was broken into and his weapon was stolen. This is his 911 call, not 911 call, but his report of the stolen weapon to the Glenn County Police and their response and report.
Well, what that has to do, same objection, Judge. 4 factors we're considering. I don't know that has to do with any of those factors.
Yeah, it's been discussed already.
It's been discussed already. In fact, the state put in a Facebook post, I believe, in which letter CC is next, Your Honor. It's a February 11, 2020 CAD detail report, transcript, and CAD detail report, transcript, 911 call. This is the call in which Travis McMichael actually encountered Ahmaud Arbery at 8 o'clock on a dark night on Larry English's property.
First, I object to the characterization of the evidence. I'm not sure that there is evidence that it was Ahmaud Arbery. But second, same objection.
Next, Your Honor, is letter P. These are the videos from Larry English's house at 220 Satilla Drive for the various break-ins on October 25th, November 17th, November 18th, and February 11th.
Same.
Next, Your Honor, is letter R. It is Matt Albenzi's, A-L-B-E-N-Z-E, 911 call on February 23rd, 2020.
Same.
Next, Your Honor, is letter D, which is, it's a merger of videos taken from Ronnie Olson's house at 219 Satilla Drive, Larry English's house at 220 Satilla Drive, and then back to Ronnie Olson's surveillance video. So essentially, you see through this video Ahmaud Arbery's path from down Satilla Drive into Larry English's house and out of his house.
The date, please.
2/23/20.
No objection to that.
Next, Your Honor, letter E are screenshots taken from those videos of Ahmaud Arbery.
Date, please.
2/23/20.
I don't know how it goes with 4 criteria, but it's not
Those
video.
aren't covered. For some reason, I'm not up to state of the screenshots. Y'all objected to screenshots when you say you want to do it. Call that objection. So that's just part of the video anyway. The video speaks for itself.
Okay.
Judge, to clarify, I believe you let the screenshots in yesterday. I believe the ruling was since the video came in and there were screenshots from the video that they were in. I just want to clarify on that.
Well,
So I'm not sure, do you still object to it?
let's do this. Are we all agreeing screenshots are coming from videos?
I mean, if,
Back there?
I don't have an objection to that. I mean, it's from that date, the 23rd.
What, are we just planning to close with a complete rendition of everybody's version of the case at this point? Is that what we're doing?
I think we're talking, no, Your Honor, the state certainly is not. We're planning on talking about the 4 IL factors that are at issue for bond. That's the state's intention here. I'm not sure what the defense's intention is, but seemingly maybe in line with what the court has articulated. I can tell the court that for what I have prepped on this Mondo pad, we are specifically going to be talking about these 4 factors and how individual facts pertaining to this case and the surrounding evidence provided to the court deal with the 4 factors and nothing else.
And that's exactly what we're planning on doing. We have to respond to what the state has already put into evidence, including a preliminary hearing transcript, which the court has indicated it's read and has cited in its previous bond ruling.
Let's see where this goes.
And just to be clear, we are not trying to try this case.
Y'all may be not trying to try this case, but you're effectively doing it. We're not going to do that today. I explained way back when we did bond hearings before. That's not what a bond hearing is for. I've given it a lot of leeway in this bond hearing. This has become a marathon. Right? There are 4 factors this court is supposed to look into. All right? Now, y'all can sit and parse every single line of everything that the other side has done. That's not terribly informative for the court. I'll tell you right now. If we can focus in on what the court needs to actually look at, that would be appreciated. I am not going to permit counsel to try this case today. Everybody understand?
We understand.
So I sure hope that whatever the summation is, pulls at the 4 IL factors, and gets me very quickly to the issues you believe are relevant to the court.
That's our intention, Your Honor. Thank you. The next item, Your Honor, is letter H, I believe. Yes, this is a GBI summary of an interview with the next door neighbor, Diego Perez.
You didn't allow summaries in yesterday for the state, so I object to that.
Next, Your Honor, is letter K. This is Greg McMichael's 911 call on February 23rd, 2020.
I don't see how it's relevant to the four factors I object.
Next, Your Honor, is letter Z. This is Travis McMichael's body cam, it's not Travis McMichael's body cam, it's Officer Robert's body cam interview of Travis McMichael at the scene at the time on 2/23/20. It is a transcript of that interview so we can get quickly to the points that are relevant. I think the body cam video is already in evidence through the state's evidence yesterday.
Explain what it is again.
It's a transcript of the body cams, the officer's body cam interview of Travis McMichael at the scene on 2/23/20.
Which transcript?
We created the transcript. Not a court reporter. Well, someone we hired who is a court reporter, but it's not from a court proceeding, obviously.
I mean, I object to it. I asked for a proffer of how that shows any of the four factors we're dealing with here.
The body camera is in the transcript if it's been just created by one side. Has it been reviewed?
We've provided it.
I've received the list and I received the thumb drive, so yes, I have it.
The video speaks for itself.
Next, Your Honor, is letter AA. This is Travis McMichael's Mirandized statement to the police on 2/23/2020.
Same objection. I don't know how it goes with the four factors.
The next two exhibits, Your Honor, are FF and G. And I'm treading carefully here because of the court's rulings. These are, you can see what they are. You know what I hear?
Of course, what he ruled on.
Well, this is not 404B.
Well, this addresses, as I understand, simply from the titles, would address character issues with regard to the victim.
Under McWilliams v. State and Dixon v. State, the state of mind of the victim at the time of the incident in a self-defense case is admissible evidence, whether it's alcohol-induced or mental health-induced.
And when we get to trying the case, if it is an issue for the court to address, I will. Not being on the victim's character.
Okay, then that's fine. The other items on this flash drive I would characterize as 404B evidence, and so I'm not arguing them but I'm making the court aware that we have this evidence and we'll be seeking to admit it as 404B, not character evidence. And the only reason I say that is because it goes to the seriousness of the offense and our ability to defend it. So that's all. I'm not getting into playing anything. And with that, I will shut up. That's my evidence on behalf of Mr. McMahon.
Anything else in rebuttal from Travis McMahon?
No, that's it.
Greg McMahon.
Your Honor, on behalf of Greg McMichael, as we indicated in our November 9th, 2020 supplemental notice to the court and to the District Attorney's Office of bond evidence, we are adopting the audio, video, and all the evidence that has been allowed by the court that Travis McMichael's counsel just introduced. So that we're asking the court to consider it on behalf of both defendants.
Okay. So, because there's a mixed bag there's some things that I'll just stand by what I previously articulated to the court. I think it's the easiest way to say what I object to and what I don't.
The court consider that as evidence of the State versus Gregory McMichael.
Thank you, Your Honor. And number The next exhibit that we introduce is Greg McMichael's videotaped interview with the Glynn County Sheriff's Office on February 23rd, 2020, which was provided to the court and, well, we got it from the DA's office, but sent it on back to them as well.
This sounds precisely like what the court is concerned about retrying the case, and I object to it. It doesn't go to the 4 factors.
Your Honor, the question of the seriousness of the offense is front and center in the district attorney's case. The district attorney will be arguing that this is a serious case, and it is a serious case, as a factor for the flight risk.
So you want to get the defendant's statement?
I am introducing the defendant's statement just as Travis McMichael's statement was introduced at AA. Introducing it because if we have a justiciable defense that our client strongly believes in and we have a great deal of evidence to support, then there is less likelihood to flee and more reason to be here to stand trial. So it would be my next exhibit number, are we able to help me with that? I'll just do defendants. Defendant Greg McMichael. We'll just do the next number today, which would be 2065.
I'm sorry, I'm just thinking through. You're identifying that.
I am, Your Honor. And finally, the state intended to introduce and was able to introduce one voicemail from Greg McMichael to Jackie Johnson, the district attorney, that he made on February 23rd, 2020. I have sought the introduction as exhibit number 27 of the only other voicemail from Greg McMichael to Jackie Johnson on May 1, 2020, which we received from the state, which helps explain the voicemail to Jackie Johnson on February 23rd. They each last about 13 seconds. But it makes it very clear that it was not for the purpose that the state is intending to introduce it and trying to curry favor or seek some way to avoid prosecution by contacting the DA. But in fact, I think as the court said yesterday, it's his former boss, person who knows the most lawyers that he could imagine, and she does respond in the second. It's clear in the second voicemail that he was asking simply for a recommendation for an attorney.
I made some comment about that.
You mentioned earlier, you asked during the presentation of the state's case where they tried to introduce a picture of Greg with his boss, and where they did in fact introduce a voicemail that Greg McMichael made on February 23rd, the day of this event, to Jackie Johnson, the district attorney, as if it were to be currying favor and seeking, I think they'll argue.
I didn't make that comment. I believe there was some discussion. I don't think I would have commented on the picture itself, so I wouldn't be characterized as...
and I don't mean that. Your question and comment to the district attorney was, well, that was his boss, right?
Okay, that was it.
Yes.
I don't want people to put words in my mouth commenting on evidence, because you then went further and said that I said something about her knowing about lawyers and so forth.
Oh, then I have misspoken or you misunderstood me. I do not attribute that to you at all, Your Honor. Simply that was his boss, former boss, and it's only fair if you're considering the idea that he called his former boss, the district attorney, on February 23rd, and the state is intending to introduce that for some nefarious purpose of trying to subvert the fair administration of justice, that you hear the second voicemail that makes clear what he called her for.
For what it's worth, I don't know.
And that's it, Your Honor.
Any other evidence in rebuttal from Gregory McMichael?
No, Your Honor, that would be the end of our rebuttal evidence.
I think in the state of
No,
Florida?
sir.
All the evidence then is in on the bond matter then. So the address Travis.
Your Honor, we'll waive opening and
Greg McMahon.
Say the Greg.
Can the court see that? Yes. We are dealing today only with a motion for bond. And blessedly, we can now talk about the legal standard, which is of most important today, Your Honor. This is not, as you've indicated, a trial of the case, and the state does not intend to try this case. I intend to talk about the 4 factors for each of the items of evidence that I'm about to demonstrate and show for the court. So I first want to start Dunn versus Edwards. Dunn is D-U-N-N, Edwards, common spelling, 275 Georgia 458, a 2002 decision that stands for the proposition that the burden of proof stands on the defendant. Though admittedly, under Constantino versus Warren, defendant must produce evidence as to each of the Ayala factors. Constantino is C-O-N-S-T-A-N-T-I-N-O, 285 Georgia 851. Thereafter, the state has the burden of persuasion, same case. So the burden of persuasion falls on the state. However, the burden of proof, as I'm sure the court is aware, does fall on the defense in this particular case. I will inform the court that we have a 90-day rule. The rules have been suspended, and I know the court is aware of that. Because of the judicial emergency, the normal time frames are not in play. But the reason that we tendered and it was admitted the arrest warrant and the indictment is I do want to talk about the import of the 90-day rule and specifically how the state was managed to, with great painstaking, get this case indicted in a timely fashion to show for the court that the state is not unduly delaying anything or holding these defendants without bond. I will point out to the court that the defense must show roots in the community, length of residence in the community, employment status and history of responding to legal process, and of course criminal history as well, some of which has been shown to the court this week, some of which we have questions. And then, of primary importance, what we need to be talking about are the 4 factors from Ayala, A-Y-A-L-A, as codified in 17-6-16-1. This court has the authority, or is authorized, discretionary, when a case is indicted in a timely matter, to release a person on bail if the court finds that the defendant poses 1, no significant risk of flight, poses no significant danger to person, community, or property, poses no significant risk of committing a new felony, and as the court is aware, poses no significant risk of intimidating witness or otherwise obstructing justice, which is about what we're about to talk about now. For your Honor's benefit, I want to articulate for the court that, and I know you're aware of this, the failure on any one of these prongs would allow the court in its discretion to deny bond. So let's first talk about the defendant's evidence and the factored approach that's required by law regarding roots in the community, length of residence, employment status, history, criminal history, and those types of things. This court must consider that in terms of the evidence that's presented before the court. And note that these are all factors, so none of these are dispositive for those factors that I've articulated for the court. I don't know why we're going backwards. We shouldn't be. Let's continue forward. The defendant's evidence simply does not support the proposition that these defendants are good candidates for bond. The fact that they may have done other good things in their history and their career simply doesn't show that they are good factors in this particular case for good candidates for bond. You can look at all the documentary evidence, you can look at all of the things that they may have done historically that tends to show good character and those types of things, but we still need to be focused on those 4 criteria and not on the history of these defendants. Today is not a day to give out gold stars for past good deeds and those types of things. Today is a day for this court to judge the candidacy for bond for these two defendants based on the 4 Aiella factors included in 1716-1 and nothing more. So these good character and good deeds evidence really don't shed any light on whether or not this court should grant bond to these defendants. I would submit to the court that it's actually quite a bit of a distraction. So with that, Judge, when we talk about danger, I've articulated in the state's motion and response, State's Exhibit 4, what dangers these defendants pose to persons, the community, and property based on what was presented at the preliminary hearing. And there are certain facts within that document, State's Exhibit number 4, which are instructive of the court. Namely that these individuals, these defendants, were the primary aggressors, that they had an intention to trap Ahmaud Arbery, that they used their pickup truck as a weapon. This goes directly towards danger to person, community, and property, the second factor in 1716-1. The fact that neither defendant called 911 initially, that goes to prong number 4, risk of obstructing justice. The fact that despite his best efforts, Ahmaud Arbery was not able to get away from these defendants goes to danger to person, property, and the community. And then the fact specifically of how he was executed in the street goes specifically to prong number 2, danger to person, community, and property. So we now look at States 15. The actual video, Mr. Bryan redirecting the victim. Prong number 2. Danger to person, danger to property, danger to community. Started on the big screen. I apologize, Your Honor. We've had some technical difficulties today. Would you like me to adjust the big screen so that you can see it better?
You don't need to adjust it, it's fine. I just did it blocked, so I didn't realize that was fine. If you just go ahead and start this.
I'll be happy to. We were having some issues this morning, so I apologize for that.
I may be fireworks with it.
We have 5 minutes. And I'll see if I can get your screen to play. Thank you, sir.
So, all we're doing is stay 5 minutes.
Yes, sir. I readjusted it. He's also not seeing screen share. Do we have everybody fired up? Do this. Do this. Do this. Do this. Over here. And then I need to play this with this. Right click. Over the VLC. Is that showing up on the judge's screen? Good to go. I got a break. I'm going to go to the restroom. Go ahead. You want to tell us a little higher? Thank you. Got it. Just make sure that I walk out higher or stuff. I didn't know if the screen went off or...
Okay, and y'all see everything on the screen? Y'all heard the video earlier and everything? No, we couldn't see any video. It was just like a still shot.
Come to order.
What about right now? Can y'all see it on the screen? Or... We got orange cone in the middle. Okay, so y'all see what we're seeing.
Thank you very much.
So rule one of the case, nobody touches the screen.
Agreed.
Okay. All right, we're back on.
The prong that I was focused on, Your Honor, before our break, I'll remind the court. A court shall be authorized to release a person on bail only if the court finds that the person poses no significant danger to person, community, or property. say it in the reverse, Your Honor.
Great deal of respect for all of the families and various interests that exist in this courtroom and otherwise. As in many cases, there can be evidence that elicits an emotional response. If you feel like you are one of those people, just to make sure I want to ask that you go ahead and try to take a step out if you think that evidence is going to be impactful in some way. And I say that in every case that I try, particularly when there are significant pieces of evidence that may elicit a response. So please don't feel like singling out any particular party or case. But if there's anybody here that feels that way, just please take a moment and step out. You're welcome to come back in.
To say it first affirmatively, I'll remind the court that the court shall have the discretion or be authorized to release a person on bail if the court finds that the person poses no significant danger to person, community, or property. The opposite would be that where the evidence shows that the defendants, as depicted in these photos, have demonstrated a danger to person, the community, and the property, they are not entitled to bond as a matter of right. And the facts of this case as presented in State's Exhibit Number 4, and now with the video and stills that the court has seen, demonstrate that these defendants, Greg and Travis McMichael, are a danger to person, property, and the community. And to add to it, Your Honor, that their views, their worldviews, are significant in terms of their danger to person, community, and property. They also impact whether these defendants are potentially at risk of flight based on concurrent investigations that have been made pertinent, I'll tell the court, by the defense, from the crime scene to present by the defense. This evidence that was just displayed before the court was not manufactured by the state, it was discovered by the state, and is consistent with other evidence that's been found through an examination of phone records, social media, and those types of things to show that it has great bearing on this court's decision as to the fourth prong, with risk of obstructing justice, and the first prong, risk of flight. So we have here displayed the law, and I will just remind the court that bears repeating that if you find that these defendants pose a danger to persons, community, or property, and a failure on any single prong, obviously, would require that this court deny bond, as it is discretionary since the defendants have been indicted in a timely fashion. These next photographs are a home here in Satilla Shores that was struck by a stray gunfire. And this goes directly to the prong of danger to person, property, or community, in that you're seeing property damage, community damage, and human damage. There are three subparts then to significant danger to person, community, and property, and the state is showing you now why these defendants fail on that prong on all three of those. A civilian could have needlessly been killed because of the gunfire that Travis McMichael intentionally did in the middle of that street. And but for the grace of God, that round did not strike somebody in the community. It only damaged property. But that is a factor that the court must consider, staying focused not on the trial of the case, but the four factors in this particular case. And in terms of danger to the community, I'll now submit to the court a portion of a phone call where Greg McMichael refers to what happened, the shooting, as a good deed.
I think about y'all every minute. I appreciate it. Yeah, I just all night last night. I can't sleep. I can't, go. I got my mask on and everything. I'm trying to sleep, but I can't. It's just, I wake up every 15 or 20 minutes. It's bothering me.
You've heard the old saying, "No good deed goes unpunished."
Yeah.
Well.
Yeah, that's it. That's a shining example right there.
So when it comes to risk of danger to persons, community, or property, you have Greg McMichael saying that no good deed goes unpunished, referencing the shooting in this particular case. And that certainly is belying of the mental state of this defendant who thinks that what happened was appropriate. The social media presented to the court in State's Exhibit Number 9 demonstrates clearly that defendant Greg McMichael has vigilante views at a minimum. We have presented a status update, and court has seen it, of this defendant was from Identity Dixie, which is a known hate group that's being monitored by the Southern Poverty Law Center. This is instructive for the court not only to danger of person, community, and property, but also risk of committing a new felony, and then risk of flight, I would submit to the court, most importantly, because of what the court's aware of, the ongoing investigation by the Department of Justice. Similarly, staying on the prong of danger to community, you've seen and heard about Facebook posts and things like that by Travis McMichael, where he talks about arming up and dispatching a threat. So, as to prong one, these defendants fail on that prong. They have failed to submit evidence to the court in support of this factor. The state's rebuttal evidence to the contrary shows that they are not good candidates for bond as to prong number 1. Let's talk now about obstruction and intimidation, which will be prong number 4. And the evidence before the court will show that they failed on this prong as well. A court shall be authorized to release a person on bail only if the court finds that the person poses no significant risk of intimidating witnesses or obstructing justice. In this particular case, the state in rebuttal has submitted ample evidence that these defendants have been actively attempting to obstruct justice, and the failure on any one of these prongs, including the one we're discussing now, would be sufficient for the court to deny bond. In support of that, Your Honor, State's 19 body cam video number 1 of defendant Greg McMichael. Within 1 minute, defendant Greg McMichael is identifying himself as former law enforcement in an attempt to influence this investigation and an attempt to obstruct the police officer's investigation of this particular case. So, Judge, with that, this is within a minute of officers discussing with him.
And so I grabbed my .37 Magnum. It's an old Glenn County PD issue, by the way.
Within a minute, he's throwing out that his revolver is Glenn County issued. That's a 505 of that exhibit, Your Honor. He's actively inserting to investigators in this case who are on the scene of a homicide that he's former law enforcement, such that that should be a factor and weigh in their approach. And that goes directly to risk of obstructing justice. To continue on and in support of that, from 711 to 720.
Hey, give me just a minute. I was chief investigator with the DA's office for 23 years, so I know what you got to do. I know everything,
Yeah, we just,
The defendant, Greg McMichael in particular, is very quick to insert himself and tell that he has some sort of law enforcement training above the average person, and you've heard of the post records and rebuttal of that to show that the contrary is actually true. He was not post-certified for a number of years. To continue on.
Let's go. So I haul that into my bedroom, get my .37 Magnum, just Glenn County PD issue, by the way, that I told you years ago.
Poses significant risk of obstructing justice by inserting things that are irrelevant to the case in the hopes that that will impact what these investigators were doing at the time.
Okay. All right.
This is the coroner asking questions of law enforcement.
No? Any information?
I do not.
Okay.
Yeah, there was a struggle. He ended up getting shot in the chest, from what I understand, 2 times.
Did you live around here?
Not that I know of.
the victim, he makes frequent trips to the neighborhood and gets caught on video cameras like every third or fourth night breaking into places, and nobody's been able to catch him. And having recognized him from the video I'd seen not too very long, or several days ago, I'm standing up in my front yard when he comes running by my, I'm not talking about trying, I'm talking about hauling ass past my house. I ran inside to get my son. I said, the guy that we saw the other, or he saw the other night, I said, he's running down the street. So that's when we started trying to find him, trying to catch him. And I left my cell phone, so I couldn't call anybody. Travis had his, but he was busy driving.
Note how quickly the defendant is to insert himself into the investigation of this case, which goes to prong number 4, significant risk of obstructing justice and influencing the investigation. To continue on with this evidence, State's Exhibit number 17 are phone records. And at 2:14 from the crime scene, this defendant calls then DA for the Brunswick Judicial Circuit. And at 14:34 in the phone records, this defendant from the crime scene calls Glenn County Police Department supervisor. We submit this evidence for the purpose of showing that this defendant is a continued risk of obstructing and influencing this investigation.
Objection, Your Honor. There is no evidence of the phone call at 14:34. There's some phone records in evidence, but no witness testified about what that phone number was related to. There's a phone call at 14:14 to the district, leaving a voicemail to the district attorney, his former employer, but not 14:34 Glenn County Police Supervisor.
It's in State 17.
It is in State 17 phone records. No testimony about who that phone number relates to.
It's in evidence.
There's a phone call that was made at 14:34.
And a phone record saying one phone call from Greg McMichael's phone to a number.
I understand the evidence.
Hey, if you need me to bring it up, judges, before the court, if you open State 17, I believe that you'll see that it's identified which phone call. I'm happy to open it for the court now if you'd like.
I don't think there's no dispute a phone call was made. The way it's characterized by the state is that there was a phone call made to a Glenn County PD supervisor.
It's identified as a call to Tom Junk, yes, who is a Glenn County, it's identified in the State 17. If you want me to...
No, I just want to make sure I understand the objection.
Yes.
So I understand what the objection is. I mean, there's no reporting, there's no conversation.
There is no
There's a telephone call
And
that
no
is
evidence
documented.
about who Tom Junk is. And to be clear, Tom Junk is not the sheriff. But no evidence about who Tom Junk is.
I understand.
State 18 is the voicemail left to then District Attorney, and this goes to prong number 4, risk of influencing and obstructing justice. From the crime scene.
Jackie, this is Greg. Could you call me as soon as you possibly can? My friend and I have been involved in a shooting, and I need some advice right away. So please call me as soon as you possibly can. Thanks. Bye.
This evidence shows from day one there was an attempt by these defendants to influence and obstruct the investigation of this case. As to all the evidence that was presented from defense's witness regarding Greg McMichael's former employment as Glenn County law enforcement, in rebuttal to that, we have the post record State's Exhibit 20, which you've heard about today. And I want to be clear on this, Your Honor. I am not saying, the state is not saying that the effect of these phone calls and discussions, voicemails to the DA then that it had the desired effect. That's not the standard that the court must look at. You must look at whether the defendant had the intention of obstructing and influencing the investigation, and that's the purpose of this evidence, is to show that he wanted to influence and obstruct this. So the standard is pose significant risk of intimidating witnesses or obstructing justice, and that's the evidence that we're presenting before the court now. The post records are also instructive to the court in that on the very first page, you can see that from defendant's perspective, reaching out to his former employer had a benefit to him in the past, in that despite saying that she was embarrassed by defendant's inability to keep his post certification, when called upon to intervene for his benefit, in the past that worked for him. And that makes what happened in terms of the phone call and the phone records and the voicemail, it makes those things that much more significant. In that State's Exhibit number 20, the letter documented in the post records show that it had the desired effect in the past. Whether it had the desired effect in this case, we'll leave for another day. And there is evidence, if you look at States 20, of that DA intervention that benefited the defendant at some time in the past, which is why, from his perspective, making these phone calls and doing the things that he did, including interjecting his law enforcement background, from the state's perspective, is an obvious attempt to obstruct and influence the investigation. To continue on with this evidence, Your Honor, State 17 phone records also reveal that after the shooting and before defendant's arrest, he was actively communicating with co-indictee Mr. Bryan. And I know the court will recall that evidence as presented, State 17, from the prior bond hearing involving Mr. Bryan as well. So on multiple successive dates, this defendant was communicating with a co-defendant, which goes to influencing and obstructing. And as documented in State's Exhibit number 4, this defendant actually, Greg McMichaels, referred to Mr. Bryan as an ally, which goes to this prong of intimidating witnesses and obstruction of justice. The next topic, unless the court needs me to pause, is to talk about Lindsay and social media. This becomes significant because of some of the cross-examination of Lee McMichael regarding jail calls that are captured regarding Greg McMichael actively attempting to obstruct the investigation of this case. So State's Exhibit number 12, May 16th, he's asking Lee McMichael to have Lindsay get rid of evidence in terms of social media.
Sure. You were telling me about Lindsay.
Huh?
You were telling me about Lindsay.
Yeah.
Is she there with you now?
Yeah.
She has got to stop.
She will.
You can get rid of that stuff.
Yeah.
Make it disappear. Make it go away. Because
Yeah.
accessing it. If not, it's liable to really screw us up.
Well, what stuff are you talking about?
I mean, her
Really?
post on Facebook. And
She's not posting anymore.
well, it doesn't matter. They'll go back and look at the shit she has posted. Do you remember all the crap we saw on her phone when we had it?
Yeah. Yeah. That's too late, Greg. She's already got it there.
But no, they don't. They don't already have all of it. There's people trying to get it all the time, and there's still stuff out there that they haven't gotten. She's got to close out those accounts and get the fuck off of them.
She did close out those accounts.
No, she didn't. She shut them down, but she didn't close them out. She didn't completely eliminate them. She just put them on hold.
No.
All right, well, if that's the case, then that's the case.
This is evidence of this defendant actively, while in custody, trying to obstruct the investigation of this case and influence witnesses by calling Lee McMichael and asking her to have his daughter delete things from social media that were the source of investigation in this particular case. To continue on, Your Honor. States 12-5-16, that's May the 16th, defendant talks about his own accounts and about deleting them in an attempt to obstruct the investigation of these crimes.
Well, I'm writing down what I can, as best I can remember, what are possibilities as far as
Yeah.
what codes go to get in there. Because
Okay.
I want to have them on this.
Because you're still wide open, huh?
That's what I hear.
Yeah, you never did. You never did close it, you just take it down, you never did close it down.
That's what Lindsay did with hers too, by the way.
Yeah, me too, I think.
But I'm trying, I can't remember my access codes or my, passwords. I'm trying. I'm writing down everything I can think of. I'm gonna have a list.
Well, Lindsay's saying we're gonna upgrade her phone, and that was going ready.
What's that?
You said this way, we're gonna upgrade her phone,
Yeah.
probably. But you can't close down her phone. I think they got everything they need. No. We'll change her phone number anyway.
Well, I hope they don't have all the shit that we saw on our phone that time.
Well, they do. They have everything on it. Yeah.
Again, Your Honor, staying focused on our 4 factors as we must during this bond hearing, this evidence decisively shows that defendant Greg McMichael poses an active and significant risk of obstructing justice in that he is working with family members to delete and get rid of evidence of significance after his arrest. States 12, May 17th, defendant refers to having his account killed.
Was y'all able to get my account killed?
He took both phones with him,
Good.
because I couldn't get into it. He said, don't worry about it, let me take it off.
This evidence goes directly to prong number 4 of 1716-1 in Ayala, posing a significant risk of intimidating witnesses and obstructing justice. In addition to that, Judge, if we were to continue on with States 12, and I'm not going to play multiple more clips, I don't think that's the best use of our time. He talks about a particular witness and tells Lee, when he answers the phone, you tell him flat out not to say anything. That's influencing a witness, and that's recorded in a jail call as well. So in terms of influence and obstruction, I'd ask the court to look closely at the defense affidavits that were submitted here of fact witnesses, and note all the times that Travis McMichael and Greg McMichael are referred to as having spoken to them prior to the issuance of those affidavits. That goes directly to obstruction and influencing witnesses, in that these defendants were on a campaign. It was a campaign to influence witnesses to their benefit in this particular case. Continuing on with this prong, I want to talk briefly about jail mail and the coded letter and the handbook. So that is included in States 13 and 14. States 13. Some things to note about this letter, Your Honor. From Greg McMichael, inmate ID, to Zachary Langford, a witness that you heard from yesterday, Your Honor. And here is the code itself. That's available to the court. I know you've seen it on the thumb drive. To a witness that the defense called in support of their bond here. And then for the risk of intimidating witnesses and obstructing justice, Your Honor, and also for a factor that I'd ask the court to consider about whether Greg McMichael in particular is capable of following the instructions of the court were you to grant him bond. Let us now look at the inmate handbook, which has the rules for mail. Inspected and confiscated if written in code. The purpose of putting this in, it goes without saying, Your Honor, is to show 2 things. Significant risk of intimidating witnesses and obstructing justice, as well as a factor that I think the court should consider whether, as a good candidate for bond, this defendant would be willing to follow the instructions and rules of the court if bond conditions were imposed on him, despite the fact that he is actively defying the rules of the Glenn County Sheriff's Office. Influencing and obstructing. and I don't think I need to belabor the point of the racist communications that the court heard about yesterday. That actually goes to a number of things. It could go to significant risk of committing a new crime. It also goes to risk of flight now that we're talking about a concurrent Department of Justice investigation as well. Now, Greg McMichael is not the only person who's talking about actively having people delete and get rid of evidence. Here's a phone call from Travis McMichael to Lee McMichael involving his sister and having her phone turned off to help evade our investigation in the case.
Really?
What pissed me off, you know.
Yep. Yep. I'm trying to send her away. Nobody would take her.
Nobody's done it. I don't blame them. Just turn her phone off. She's on your plate. Give her that other phone that I have for calls only, okay?
Yep.
Remind the court that the failure on any one prong is sufficient for you to deny bond. Here we have now Travis McMichael actively obstructing the investigation of this case. I now want to talk briefly about flight risks, Your Honor, which is a factor that the court must consider. It's the first prong. The court shall be authorized to release a person only if the court finds that the person poses no significant risk of flight, which I believe is a factor for the court to consider here. As shown to the court, these defendants were initially charged with felony murder, aggravated assault, and party to the crime thereof. Our aggravation notice puts them on notice that life without the possibility of parole is an option in this particular case if convicted. Their social media, evidence of racism, and State's Exhibit Number 6, the public DOJ, Department of Justice, announcement of this concurrent investigation certainly should give the court pause as to this particular prong about whether these defendants pose a good candidate, either of them, good candidates for bond. We submit to the court that because of this evidence that we've submitted to the court, they are not. And they are a risk of flight because of the possibility, I even say maybe probability, that there may be additional charges that are forthcoming for them.
That is so objectionable. We talked about this yesterday.
I think it's argument. It's the state's position. I'll take it as
The SPLC document, the business record, is State's Exhibit Number 7, and that's for the court's review as well in support of this flight risk. Consistent with that, Your Honor, you've heard about racist social media, racist messaging. There's a racist text message about having no, I won't say the word, ends around, and that's available to the court as well. This all goes to the danger. It also goes to risk of flight based on what's been shared with the court. There's some social media that was recovered by the state as part of this investigation. First, pertaining to Greg McMichael, a video clip that was recovered from his social media, admittedly sent to him, but I'll ask the court to note in context this racist song associated with this video, because it will make sense when you see the next video that I'm about to play for the court as well. And I will caution the court that in terms of this racist video, it's a little disturbing.
Oh, you got some music on your phone sending me quiet ass call with your ass? Yeah, bro, I got slaps.
I'm an Alabama nigger and I wanna be free. Hell with the NAACP. I don't drink, I don't cuss. I wanna ride on the front of the bus. I'm an Alabama nigger and I wanna be free. Hell with the NAACP.
In context, Travis McMichael received a video, laughed at it, and turned around and resent it to a friend of his, involving the same song dubbed over another video. So you have the same song, different video, two defendants living in the same house. In this instance, Travis McMichael, having received it, laughed at it and sent it.
All right. Well, I think it's time for us to...
Understood. In sum, Judge, as I submit this to the court shall be authorized to release a person on bail if the court finds that the person poses no significant risk of flight, danger, risk of committing new felony, risk of intimidating witnesses, or obstructing justice. Your Honor, we've presented evidence in rebuttal as to each of these 4 factors, and any one of which would be sufficient for this court to deny bond and bail in this particular case. So my final thoughts, Your Honor, is that you should deny bond here. Defendants are not entitled to it. They've been indicted in a timely fashion. There are no time frames that are applied to them because of our judicial emergency and because of the timeliness of our indictment, nor are they deserving. I submit to the court that the evidence presented to the court shows that they are poor candidates for bond. They're not entitled to it. I will remind the court that we are aware of a pending speedy trial demand that's been filed by co-defendant Mr. Bryant. Fortunately, because of the judicial emergency, we don't need to be too worried about those time constraints now, and I understand the terms of court here in Glenn County are 6 months versus in Cobb where they happen to be 2-month terms. But my point in saying that is we're cognizant of the fact that we've been put on notice that speedy trial issues, once we're able to try the case, will be an issue, Your Honor. And I can stand here affirmatively for the court and tell the court that we'll be ready. As soon as it is feasible to try this case, we'll be ready to try the case. I would suggest to the court that the appropriate remedy today is to deny this bond. And if we're unable to get this case ready and tried when it's feasible for us to do that, the issue could always be revisited by the court at some later date. Thank you, Your Honor.
All right, thank you, Mr. Evans.
Your Honor, it's a bit like being in Wonderland, where the actual characteristics of a person don't matter, but the information, the evidence that's in dispute is what the state's asking the court to rely on to deny bond. The best predictor of future behavior, which is what this court has to do in this case, in determining whether to set bond, is past behavior. Travis McMichael twice has sworn an oath to uphold the laws, to abide by the laws, to follow orders as given. Once when he enlisted in the United States Coast Guard, and the second time as a commercial captain with Metzen Marine. Everything about his life has been consistent with upholding his oath to abide by the laws, to follow orders when given, and to go above and beyond the call of duty. That's who Travis McMichael is. And the state glosses over and says, we don't need to worry about that. This is not the day for gold stars. This is the day for gold stars. This is when past behavior matters. Because it's up to this court to examine the person who you've never met, you know nothing about, until we provide you evidence. Evidence in the form of witnesses who know Travis McMichael. Evidence in the form of a criminal history printout. Evidence in the form of documentary evidence. I mean, that's what we've done over the last day, and I know it's been a marathon. But we brought to the court Travis McMichael's mother, subjected her to cross-examination, and what she told you is, Travis, born and bred in Brunswick, all of his ties are here in this community. He's got a now 4-year-old son, the court has pictures of, who means the world to him. Suggesting, Your Honor, fairly strongly that he's not a risk to flee, because if he did, he would never see his son again. You know, it's easy to get a preacher to come in and say good things about a parishioner. That's kind of their job. In this case, we have the mother who is no longer, the mother of Everett, who is no longer in a relationship with Travis, who shares custody 50-50, who engages with Lee McMichael on a weekly basis, who is still part of their lives despite the fact that they don't have a relationship anymore. They just share Everett. And I think that speaks volumes for Travis. Lee McMichael told you about Travis's financial situation. He's got very little money. I think she said he had $6,000 to his name. Where can he possibly go and survive with that amount of money? Not to mention the media that's present and covering this case. Where in the world could Travis McMichael go, flee the jurisdiction of the court without being seen, recognized, and delivered back, never to see the light of day again? It'd be ridiculous. Travis McMichael has abided by every order ever given to him by commanding officers. And that's why we took the time, and I know it may have been a little bit wearying, but we took the time to put in all of those things about his Coast Guard career. The state wants to say he's dangerous. He poses a danger to the community because he has private exchanges of an offensive nature, no doubt about it, with his friends in the community. But if you look at his behavior, his actual behavior towards other people, towards people of all races, all religions, all socioeconomic classes, you see a man who is known as the life of the party, funny, a mentor, someone you want there with you when things get dicey. You saw the letters of commendation, the lives he's saving, black and white, when people are in trouble. Kurt Hall, sergeant in the Marines, a person of color who lived with Travis McMichael during the time they were posted, I believe, in Pascagoula, who had nothing but wonderful things to say about Travis as a person, as a Coast Guard enlistee, and as a man. And so if past behavior predicts future behavior, that's who you're dealing with. Someone who abides by the rules, someone who is willing to abide by any conditions this court sets, someone who goes above and beyond to save people, no matter what private offensive messages he has with friends. That's a diversion. And you know it's a diversion, Your Honor, because you have Travis McMichael's criminal history. He's 34 years old. There was not one thing brought into evidence by the state to indicate that Travis McMichael commits felonies or poses a danger to anybody except the disputed facts of this case. He shows the video, the now infamous Roddy Bryan video, to prove that Travis is a danger to the community. But as my esteemed colleague, Mr. Hogue, has once said, that's the knothole in the fence. To look at that video and claim that Travis McMichael is a danger to the community fails to see not only the span of this case, which we will get into, but the span of Travis McMichael's life. And so when we talk about Ashley Langford, Ashley Sawyer, Lee McMichael, Zachary Langford, Sean Sawyer, Kurt Hall, we are talking about people who grew up with Travis, who have known him since grade school, in the case of Lee McMichael, obviously since he's born, but certainly from grade school, high school, Coast Guard, post-Coast Guard, Metzen Marine, living in Brunswick, this county. He's not a danger to flee. He's not a danger to the community. In fact, He is an asset to the community, and he's proven that by always being employed, paying his taxes, never getting in trouble, never confronting people unless he himself is put in danger. And that was one time by one man named Ahmaud Arbery. And actually, Mr. Arbery confronted him twice. Nobody else in the span of Travis McMichael's life has had a run-in with him. The Ayala factors, the bond factors, risk of flight is not risk of flight. It's significant risk of flight. It's significant danger to the community. It's significant risk of committing a new felony. It's a significant risk of intimidating witnesses. We put into evidence 3 affidavits: Matthew Albenzi, Ronnie Olson, and Diego Perez. All 3 of whom have had conversations with Travis McMichael, as Mr. Evans points out. They had conversations with him prior to February 23rd, and they had conversations with him after February 23rd. And not one of those conversations has been any kind of attempt to intimidate. In fact, as the affidavits say, they themselves swear there's been no attempt to intimidate them. But even better than that, Mr. Evans has a whole file, a stack of documents of interviews by the GBI. His evidence shows there's no attempt to intimidate by Travis McMichael. They've all been interviewed. Diego Perez has been interviewed probably twice. Matt Albenzi at least twice. By Glenn County, by GBI. None of them have said Travis McMichael tried to sway their testimony, intimidate them one way or another. It's ridiculous to play these jail calls or make insinuations that Travis McMichael is trying to obstruct justice. There's nothing about him in his background that is consistent with that argument. There's months and months of jail calls from Travis McMichael to his mother. There's no phone calls to Matt Albenzi, no phone calls to Diego Perez, no phone calls to Ronnie Olson or any other witness in this case with Travis saying you need to testify a certain way or don't testify. He's made a big deal about telling Lindsay to get off her phone and close her account. This poor girl, with whatever kind of judgment she lacks, takes a picture of the scene on February 23rd and posts it. It's not evidence. They have 1,000 pictures of that same scene, but it is incendiary, and there's no point to it. It just creates passion in the community and infuriates people, as it should. It was a bad mistake by Lindsay. So rightfully, Travis wanted her to take it down. Doesn't help him to have that picture out there. It's not get rid of it. There's 1,000 pictures of the same site. It didn't hinder the investigation whatsoever. February 23rd is the date of the incident. He's not arrested until May 7th. There's not one piece of evidence presented to this court that in that time span, March, April, first week of May, Travis McMichael made plans to flee the jurisdiction of the court, talked to anybody about the possibility of fleeing the jurisdiction of the court, attempted to intimidate witnesses or obstruct justice, committed any new felonies, or posed any kind of danger in the community. He's never posed a danger before or after February 23rd. And I would submit to the court, he didn't pose a danger on the 23rd. The danger came from Mr. Arbery. The court has mentioned, of course, several times, and we've gone over this preliminary hearing transcript. The problem with relying on a preliminary hearing transcript is the goal for the defense in a preliminary hearing is not the same, as we've pointed out, as in a bond hearing. Agent Dial was not challenged for the accuracy of his testimony at the preliminary hearing. Quite the contrary, the questions posed to Agent Dial were open-ended questions, as the court recognized, designed to get discovery. It was not really a question of probable cause. And so when Agent Dial testifies that Ahmaud Arbery is a video game player, a jogger, an athlete, that doesn't go challenged. And so we don't want the court to think because it doesn't go challenged that it actually is the truth in the case. There are a number of instances in the transcript where Agent Dial is flat out wrong. And that is why we put some of these matters into evidence, not only to show that the preliminary hearing transcript is inaccurate as it relates to Agent Dial's testimony, but to show the court that this knothole, the state wants the court to view the case through, is incomplete. It's obviously too small a perspective. You need to knock down the fence and look at the whole case. And this is what the case is. And this goes to future dangerousness or risk of flight. You have, Your Honor, the Satilla Shores Facebook page. There's no question that the neighborhood was on edge, that there had been an uptick in property crimes dating back to 2018, certainly by 2019. Everybody's talking about it. Hey, there's been another break-in at the garage. There's been a theft of weapons out of cars, both in Satilla Shores and Royal Oaks, which is the next door neighborhood. I guess on the south side of Highway 17. Greg McMichael sees a man in July of 2019 that he thinks looks shady. He's living under the bridge. There's already property crimes. He's concerned that this man might be the guy who's causing a lot of these break-ins in the neighborhood. So what does he do? He calls the police, Glenn County Police Department. He doesn't pull a weapon on this man. In fact, the man is a white man who's homeless, who lives under the bridge. Officer Canego responds, and there's really no reason to suspect this man of anything. And nothing happens. Greg McMichael nor Travis caused any problems for this man. They just wanted the investigation to be done to make sure he's not responsible, because they are also on edge like everybody else. But the man was not black, and that's what's significant in this case. If the state wants to argue that Travis McMichael, because of his offensive private exchanges with friends, poses a risk to the community, there's no evidence to support it. What was concerning was that someone, white or black, was committing these crimes, or some group of people. October 25th, Larry English has a break-in his house. He calls the police. There's video of it. He says there's a man plundering my house. He looks like he's drunk or on drugs. He's kind of stumbling around. This we would submit as Ahmaud Arbery's first encounter with Larry English. It's at night. He has no reason to be there. Agent Dial testifies, well, maybe he's looking for water, or maybe he's interested in the electrical system of the house. It's at night. Larry English calls the police. He does not get caught, obviously. A month later, November 17th, there's actually a couple on the property. Larry English calls the police because of a white couple on the property who he suspects of stealing or intending to steal from him. He relates in that call, I believe, that items were stolen previously during the previous intrusion. $2,000 worth of equipment was stolen from a boat parked inside the house on the property. The only person we know was there previously is Ahmaud Arbery on October 25th, 2019. The very next day, November 18th, Ahmaud Arbery is back in the house where he shouldn't be at night when he shouldn't be. English calls the police. Again, they can't catch him. English relays to the police, hey, today on the 18th, I got my boat out of there. It had been ripped off. I lost cooler. I lost electrical equipment. I had to come get my boat out of there. So when Agent Dial testifies at the preliminary hearing that Larry English never told us anything was stolen, well, either they did a bad interview of Larry English or Larry English lied to him. Because he's on 911 call, and the court has it, describing the items that were stolen out of the house, out of the boat during this time period. And he's sharing these videos with the neighbors, with Diego Perez, who's sharing them with others, and they're talking about it on the Facebook page. The very Facebook pages that you have in evidence. December 1st, Larry English calls the police again because he sees a guy, or sees the car that he thinks belongs to a guy under the bridge again. We're back to the under the bridge guy. And he wants the police to come investigate. And he's talking to Officer Rash, both through official channels and on his cell phone during this whole time period. That turns out to be nothing. I don't think they ever found the guy. There's no real report of what happened after that. January 1st, New Year's Day 2020, 2 cars that I know of are broken into and weapons are stolen. Travis McMichael, and you have that police report, he calls the police, and a woman named Christy Barber in Royal Oaks, a neighboring neighborhood. And she has multiple weapons stolen out of her car. All this, again, is plastered on Facebook and everybody's talking about it. And it's dangerous. Someone is stealing their guns. So now people have guns illegally. Critical date for the court is February 11th, 2020. Travis McMichael is driving to the gas station at night, 8 o'clock at night, to get gas for the next day when he drives to work. As he passes Larry English's house, he sees a man trying to hide, trying to act furtively, hide behind the porta-john that's out there, and he kind of backs up and puts his car lights on that person. He sees that person, who we think is Ahmaud Arbery, reach into his pocket as if he had a weapon. Travis immediately backs up, goes home, calls 911. Officer Rash and other officers come. Diego Perez comes over. Everybody's trying to catch the man we now know as Ahmaud Arbery on that property. But now he's armed, or suspected of being armed, and he's committing a burglary. He's at that house for the 3rd time now in 3 months, when he has no business being there. And that's why when they see him, when Greg McMichael sees him hauling ass down Satilla Drive on February 23rd, he knows who that is. And I say hauling ass, that's in quotes. That's how Greg described it. And the only reason they had weapons, as they say in their reports, is because they believed he was armed, based on the prior incidents. That's the broader picture. So yes, when Travis McMichael posts, we need to arm up, we're under attack. We Satilla Shores people, we Royal Oaks people, we're being ripped off left and right. We need to protect ourselves. They now have guns, by the way. Our guns, whoever they are. We got to be careful. do anything? Is there any evidence that during this time period, Travis McMichael took it upon himself to be a vigilante? The word Mr. Evans likes to throw around, Officer Rash would call it neighborhood watch. Yes, keep your eyes open. If you see somebody, call the police. That's what he does. That's what he does on February 11th. You have Travis McMichael's statement. He thought his dad had called 911 on February 23rd. Greg McMichael forgot his gun. By the time Travis realized 911 had not been called, he called it himself. And he gave his phone to his father, and you have Greg McMichael's 911 call. You have the body cam of Travis McMichael's interview with the police. At the scene, the man had just shot someone who attacked him. He cooperates immediately with the police. He says, literally, do whatever you have to do. Don't mind me. He's covered in blood. He tells the police within seconds of the incident, literally seconds, what happened, how this occurred, and he tells them exactly what I'm telling you. He goes to the police station an hour later. By the time they get him down there, maybe it's 3 o'clock, 3:30. He provides a written statement and a map of exactly what happened. Not only on February 23rd, but going back to January 1st when he was a victim and his gun was stolen, February 11th when he saw this man that he recognized on the 23rd. He cooperates with the police in every which way. Talk about administrative obstruction of justice. Travis McMichael is the poster child for cooperation with the police. He's read his Miranda rights. He could say, sorry, I'm not giving you a statement until I talk to my lawyer. He gives a full written statement, which you have. He talks to the police on the scene. He's law enforcement. He has had arrest powers. He understands the job they have to do. He wants them to do their job. He gives them the evidence to do their job. This man is not a risk of flight. He poses no danger to the community whatsoever. Certainly not a risk of committing felonies. And we know, with facts and not speculation, that he's never tried to intimidate witness or obstruct justice. If the court has fears that if I grant a bond, some of these things could happen, there are ways to prevent that. The court could order a bond secured by pillars of the community's property, people who are willing to put their lives at risk, certainly their economic lives at risk, by providing security in the form of their property. I think we totaled it up to about $400,000+ worth of equity. To secure his appearance, the court could order house arrest, either in this house here in Brunswick, or in another house in Brunswick. I think Zach Langford said he would take him in. Or, if the court felt there was a safety issue, we could put him in a relative in Florida. He could waive extradition. He could wear an ankle monitor. You would know where he is at all times. You could require him to surrender a passport, which I think we heard from Ms. McMichael, there's no passport. You could require that he not possess a firearm. Make sure no one else in the house in which he lived possessed a firearm. Any qualm the court has about the 4 factors can be remedied with conditions of bond, and should be remedied with conditions of bond. That's the appropriate way, with all due respect, to handle this situation. Travis McMichael is not a career criminal, nothing but abided by the law and rules his whole life. He will abide by this court's rules. He will abide by this court's conditions. And we would ask this court to set a bond pending trial where these issues in dispute can be determined. Thank you.
Thank you. Let's take 5 minutes.
Can we let them know that?
Yeah, they're just on live, right?
Guys, your mics are alive, so we can hear you.
That seems
Can you hear me?
Yes.
It seems loud for some reason.
It does.
A basic volume control is not going to shut it
There's
off.
a knob on the speaker right now. Would you help me adjust it now?
Yeah, it's just adjusted down a touch. Although given Mr. Evans' history with this,
Do not.
I hate to say that there are similar transactions on your own.
okay, we're back on. Everybody is present.
Thanks. A life well lived, of service to his community, earning the respect of respectable people, committed to his marriage vows through thick and thin, with absolutely no criminal history and not a single complaint ever made in his 64 years on this planet related to aggression, violence, or disparate treatment. The defense has met our burden of production on the 4 Ayala factors in overwhelming measure, Your Honor. Roots in the community that are long and deep, length of time in the community, lack of criminal history, and good worth for decades to this community. He's not a perfect man, no one is. Health and finances required him to have some blips in his training record that he addressed appropriately through the measures that the post director told you gave him the right, and because it was a notable situation of a medical condition, to get those waivers of exceptional circumstance. I take great offense to Mr. Evans' comment that we're just up here talking about history, and that's just the past, Your Honor. That just couldn't be any further from the truth. History is the only reliable measure of a man's character. It's the only accurate predictor of future behavior. It is not, as the state characterizes it, a distraction. It's not smoke and mirrors. It's the basis, the foundation of the evidence you must consider in evaluating the factors. So, after an overwhelming presentation of those factors under Ayala, what has the state done to attempt to rebut that? Let's talk about the factors one at a time. First, is there evidence of significant risk of flight or failing, or concern of a failure to appear in court? The state's argument is that the strength of this, that the seriousness of this offense, and it is the most serious offense you can have, coupled with some potential DOJ investigation, is enough to persuade this court that Greg McMichael will not be in trial. But what we were able to show you, Your Honor, without trying to try our case, but simply providing the rebuttal to you of why Greg McMichael has no desire to be anywhere on the day of his trial but right here, is because we have a strong defense. This case, despite all that we've heard, is about whether Greg McMichael, on February 23rd, was authorized to protect his neighborhood against crime the way that he did, to do the good deed that he describes on the phone, of putting himself out there to protect his community. This case is about self-defense and whether under the private citizen arrest statute and the justification statute, as Greg McMichael believed he was, whether he had the right under the law to arm himself to attempt to detain a person he believed, as you hear in his interview, with 100% certainty, and in fact, he was right, was the person the police had been coming over to their neighborhood to try to detain themselves. A person who was coming into a home under construction day and night, followed by reports of things having been stolen from that home. People of good character who have a significant stake in this community, Your Honor, came before this court and told you Greg McMichael will be here. He needs his trial. He's a man of his word with over 30 years in law enforcement, with a wife he loves, and a grandson that he adores. But not only did they just tell you this, Your Honor, they put their money where their mouth is. They provided to you evidence of hundreds of thousands of dollars of unencumbered property that they will stake that belief on for this court, knowing the ramifications if their friend, former colleague, respected member of the community did not reappear for court. And you also heard why else he's not going anywhere but staying here in Glynn County. After 2 heart attacks and a stroke, his critical life-saving needs to continue to see his cardiologist, his neurologist, and his GI, to be able to be home to get that loop implant wired back up to that black box that will let anyone know if AFib, atrial fibrillation events are occurring, so that he doesn't sustain another stroke, are the reasons he will have to stay in Glynn County if released on bond. Danger to persons or property and the danger of committing a new felony. We're going to put those together. And what does the state say to you? Despite a lifetime of nonviolence, the state says, it's the case, Your Honor. It's our case. Watch the video, and you will be persuaded of a predictor of future behavior. Well, Your Honor, that's just not realistic. A man does not wake up one morning and become a violent, race-motivated killer. That's not how it works. With no complaints in his past, no evidence of some history of violence, to do what the state continues to characterize this case as hunting down another human being in his neighborhood, The video that they chose to play shows this court any number of opportunities for a race-motivated, hating, vigilante murderer to have shot down Ahmaud Arbery dead in the street. If it was for the act, some supposed happiness or glee, desire to be that sort of person, you have a video that shows you all the opportunities someone who would be that sick and awful would have taken, could have taken, to have murdered Ahmaud Arbery. In fact, you see that Greg McMichael doesn't even take his gun out of his holster until Ahmaud Arbery bolts left and attacks Travis. But the state says, no, that's not the man. All you've heard of him is not the man you should think he is. Because after going through thousands and thousands of pages of Facebook history, we, the state says, found a couple things on his Facebook page. Can't tell you whether he saw them. Can't tell you whether he liked them. Can't tell you whether he commented on them, thought they were great, thought they were horrible. And these, Your Honor, one post on April 17th, 2019 that has the word Identity Dixie on the bottom of a picture of two children, that is what they're asking you to make this enormous leap from, to now make Greg McMichael into a racist murderer. That is not how justice works. That is not how this courtroom should work. And then, of course, the bombshell at the preliminary hearing. The effing N word that only came up in Roddy's fourth interview after trying desperately to work with the police, Roddy Bryant, to get out of any criminal exposure in this case, is when you heard at the preliminary hearing, or you read in that transcript, that Roddy Bryant said he heard that. Even though you now know with the 911 call that Greg McMichael made that we have in evidence, the line remains open. Even to the time the police arrive and you hear nothing from that phone in the cab of the truck. But race, the state says, and racism is what should make you be afraid to release Greg McMichael on bond. I don't want this to sound flippant, Your Honor, but to hear the state talk about this case, from the preliminary hearing to every court filing in the case to this hearing on bond, you would think that the race of Ahmaud Arbery is the only thing that makes the state of Georgia concerned about a serious event on February 23rd. That if in fact this was Arnold Arbery, a young white man who'd been repeatedly seen in Satilla Shores, a neighborhood on edge from repeated crime, caught at night on video more than once in a home under construction where items then went missing. That if Greg McMichael saw Arnold Arbery, chose to follow him in hopes of detaining him so that the police could get to the bottom of these crimes, but then Arnold took a left and attacked his son, forcing Travis McMichael to turn into a killer. That the state just doesn't sound like they'd be all that riled up about it. This case isn't about race, Your Honor. This case in the indictment is about whether or not the private citizen's arrest law and the justification statutes allowed Greg McMichael to do what he chose to do that day for the sole purpose of defending his family and his property and his community. And finally, the state, under the fourth Ayala factor of a risk of influencing witnesses or otherwise obstructing justice, points to the ally phone call that he has with his brother. Well, Your Honor, the antonym of ally is enemy. And as we're all aware, in this day of cell phone access, there are plenty of cell phone videos taken by onlookers whose sole purpose is to try to say that the person they're taping is doing something wrong. Ally means no. This videotape, as horrible as it is to watch, is exculpatory. It is the only proof of what Travis and Greg McMichael said at the scene immediately, and that is he attacked Travis. Who could ever believe that had there not been that videotape? That's what that word means. The state says that the minute the officers arrived on scene, Greg McMichael told them that he was an officer, and I'll use their characterization, in the hope that it will impact how the case would progress, inserting himself into the investigation. Your Honor, here are the clips. I'm not a danger to you right now. That's the point of him telling all the various reasons he's saying it, let alone the adrenaline that's running at the time that this has all happened. His context is, you don't need to worry about me. I've been where you've been, ladies and gentlemen with uniforms on. I'm not going to run. I'm not going to hurt you. I'm not going to bow up when you try to get evidence from me. I understand, the quote is, that you've got to do a full investigation. I'm going to comply with what you need from me. And then the fourth time is when people who begin to recognize him. Right. Yeah, we knew each other from the police force. Not an attempt, hey, come on, between you and me, just let us go. There is no evidence that anything Greg McMichael did or said on the scene had any impact on it, and nor did he seek to, in the proper context of those body cam videos, did he seek to do anything to get or curry any favor. And then the phone call to Jackie Johnson, his former employer of decades. They played the one. Now here you now have into evidence the second one. Hey Jackie, this is Greg. I have retained Alan Tucker, took your advice. I think Alan's going to do me a good job. And then he goes on to thank her so much for your advice. Because who else, who better knows how to seek help in a criminal case? Who knows the criminal defense community but the district attorney? There's no suggestion that he's seeking to get some help from her. Cover me here, Jackie. Help me out. Keep me informed of the investigation. Put me on the back burner. Absolutely nothing like that. The other thing they cite as and the obstruction of justice is Greg McMichael's emotional request to his wife to get his daughter off of social media, to take down that tasteless post of a crime scene. She wasn't posting anything. She didn't have any evidence to seek to get rid of. It's his daughter who did a thing that he found offensive, and he wanted his wife to make sure that she didn't do things like that again. And the telephones, as you heard, were already gathered by the investigator, by Lee McMichael, given to the investigative team that then went over to Agent Dial. Agent Dial testified at the preliminary hearing. Nothing was scrubbed. They took everything. Everything was clean and orderly, just as you would expect a former law enforcement officer to do, because he respects the law. And then the affidavits that we introduced in the case in chief of the surrounding neighbors to say to this court, Greg McMichael is doing nothing to influence me, to intimidate me. Nothing will change about my testimony if Greg McMichael is out on bond. The state characterizes that as a campaign to influence witnesses, to talk to your neighbors in the months that you're home after this horrific event in your community. All the neighbors that had been on edge, who'd been trying to put their heads together to decide how they're going to handle this continued crime in their neighborhood. And then the last was some postcard of gobbledygook, and that sent out to his son's friend, and some suggestion by Emmanuel that he must have known the rules and chose to break them. That's not a rebuttal to the significant evidence in support of those factors, Your Honor. Jesse Evans said to you in the beginning of his argument, bond as a matter of right. Well, that's really not an accurate representation of what the statute's all about. The phrase bond as a matter of right refers to cases that are not indicted within 90 days. And they sure did get this indicted within 90 days. Bond as a matter of right means, Judge, you don't have any discretion. You've got to give them a bond. Yes, of course. This is not a case of bond as a matter of right. But here's where the state has mischaracterized it from there. Outside of an instance of bond as a matter of right, liberty is the norm. Detention is the limited exception. The purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of the person in court for trial. Otherwise, Your Honor, what we're doing, if you have not been persuaded that Greg McMichael poses a significant risk of not being here or becoming the man he never was before and becoming a dangerous man suddenly in the 64th year of his life, or to intimidate witnesses after a life of service to law enforcement, if you have been persuaded that that's not what's going to happen, that he'll be here and he'll be safe out there, then your not setting bond is simply beginning his punishment. He spent 6 months in the county jail and respectfully waited until we could get the pandemic to a place where we could have this hearing. He is a worthy candidate for bond, despite what you hear from the state. And in fact, he does not give you the significant, compelling, and legitimate government need to deny him his right to liberty and freedom so that he can defend himself against these charges. Please, we ask you to set a bond in a reasonable amount that can be secured by family's property and to allow him to go home to work with his lawyers. Thank you.
Thank you. Here is what I plan to do at this point. Let me find or figure out where we are on some of these remaining issues. So I want to digest a few things before I get to the point where the court rules. Bond was not the only issue before the court for this hearing. Also before the court were the special demurs filed by all three defendants, a motion for a joint motion for the deposition of Larry English, state's motion for an ex parte hearing, and then, as I said, there's a motion to adjourn the state, which the court has already ruled upon. With regard to the special demurs, are we having legal arguments here today? Is there additional evidence that the parties intend to present? Probably the easiest thing to do is start with defense.
We filed two on behalf of Greg McMichael and Travis McMichael joined in those. There's no evidence to present for either of those through this legal argument, and quite candidly, the legal argument I can make here will not expand on what I've written, but I'll be glad to engage in a conversation about it if the court would like and discuss the issues I've raised, or if I've written anything that's not clear, I can clarify it. But there's no evidence required for these two matters.
And Travis McMichael is joining, and I believe also Mr. Ryan is joining.
Yes, I would not add anything to whatever argument Michael present on those two demurs. Oh, I'm sorry.
You're both nodding your head.
We
I didn't want to remind you of the court reported.
We join in the equipment.
And from the state?
Yes, Your Honor, Linda Dunn-Cassidy for the state. The state is in agreement with the defense that you should go ahead and rule on the written motions that we submitted in response from the state.
All right. The reports outlined the demurs. What I wanted to make sure of today was that beyond what was submitted in the briefs, there's going to be no additional legal argument or evidence for that matter. That being the case, and understanding that from the sounds of things, everybody's willing to rest upon the briefs, I'll just move forward then with what I've outlined and go through the legal issues that have been presented. So at least for the purposes of today, I'll address that upon the briefs with no further action at this hearing.
Yes,
okay.
Your Honor, thank you.
There is, let me address this one because I think this is pretty straightforward. It was kind of an odd filing, at least as far as I was concerned. The state's motion for an ex parte hearing, this had to do with what has occurred in this case. There have been a number of joint filings on behalf of Greg and Travis McMichael. I mentioned yesterday, I think, this case, as much as it may seem at times that I get frustrated with the amount of lawyering that's going on, one of the things about this case that is a positive is that we have experienced lawyers that know how to try a case and know how to get a case ready. And I say that because I'm not sure I really want to get into an ex parte hearing on conflicts of interest. I trust, and unless I hear otherwise, that counsel for Travis McMichael and Greg McMichael are fully aware of their professional obligations to their clients to the extent that it is necessary or has been necessary, and I don't want to know because I don't want to get into any contact between clients and their counsel, any privileged information, but to the extent that their clients need to be informed of whatever the defenses are and what type of decisions are made with representation, I assume they've been fully informed. Unless I hear otherwise at this time, I'm going to assume that that has occurred. Fair enough?
Yes, sir.
That's right. Thank you very much.
That's the way I will address that motion. I'm not going to put anything in writing. I believe that by bringing it up in open court with the clients present by video conference, that I've touched upon what I need to touch upon on that motion. And I've got a joint motion for the deposition of Larry English. What I'd like to hear is what it is, and I've read the brief. It's rare to take the deposition of a witness like that, and there's no indicate, although there's some medical issues out there. We don't have a trial date, and I don't have any acute issue that I'm aware of that demand the court move forward. But I'll hear from the defense as to why this is being brought up now.
Yes, sir, and I believe in speaking with the state that they join in the motion, they will also seek this deposition. It is my understanding from speaking to his counsel that he has a serious, significant heart and lung problem that's outlined in his doctor's letter, that he is at risk of getting COVID-19, and if he does, then he'll have some serious consequences as a result of his underlying illness. He's a high-risk patient. And so, given that we don't have a court date, and we don't expect to have one anytime soon, it will be 2021 before we do, we fear that his condition could worsen to the point where we can't get critical evidence into the record. And I think the state feels the same way.
So it may very well be that we acquiesce in this motion at some point. I do have an update from Monday, and I appreciate the fact that we've been able to have this dialogue from the attorney that represents Mr. English. She texted me late Monday night and says that Larry English has an appointment next week. I don't need to give the details on that, and she would like to follow up with us on that. So subject to me getting more information after next week, if we could revisit this with the court. I just don't think that right now there needs to be an argument or a ruling from the court. Let us, if it's okay with the court, to continue to talk about this issue to see if there's some agreeable ground. But I won't know more until probably the 19th.
And that's fine. We've been working well. I talked to Mr. Evans more than I talked to my wife. We faced much of a consternation. So I'm happy to continue the conversation.
Okay.
And assuming we all.
Yeah, we're good.
Okay. Well, it's always good to hear the parties are discussing things. Obviously, with a deposition of this nature, the court's going to need to get in the loop if this gets along any further. There's a lot of questions I have about how this would occur and what needs to be done in order to get the court to a comfortable place on it. Okay. But I understand I believe those are all of the matters that were on the court's notice of hearing.
Yes, Your Honor, we wanted to ask for one additional issue. In the court's scheduling order, you set our motions deadline, the defense's motion deadline, for the end of this month. I think when the order was set, we none of us probably anticipated we'd be spending a couple weeks in November getting ourselves ready for the bond hearing. Probably figured we'd have done it much earlier. But this has taken a considerable amount of time, and we're going to be moving right into the holiday, the Thanksgiving holiday. And for all four lawyers, we've had to put a lot of things on the other cases on the back burner. We each have an incredibly busy week next week to do the things that we had to put aside. We've spoken to the state about this. They don't seem to have any opposition to our request for at least another 30 days and to make it to December 31st for us to get to you our pretrial motions. The other important piece is that while the state has given us almost all of the evidence, there is still evidence outstanding from the state, they've told us. So until we've received everything that we need to review, we'd like the opportunity to have a little more time.
First, so that the record is not silent on this, I don't recall whether we discussed it or not. We did have a scheduling conference remotely with the court, which I think was beneficial, so I want to perfect the record on that, where the court essentially offered to conduct this bond proceeding earlier but remotely. And it was decided by the defense strategically that it was their opinion that doing it live would be beneficial to them. So I want to make sure the record's clear that since delay was brought up, that the court was willing, as was the state, to do it earlier, but it wasn't feasible, which is completely understandable from the defense's perspective. That's their strategic right. So second, it is accurate that I do not have some things to turn over in discovery. We're talking about digital forensics. I have obviously a lot of digital forensics, but it's been complicated by, I won't get into the details, but ability to get into certain devices and passcodes and things like that. So I personally don't have it. The GBI continues to work on that, and we continue to be in communication weekly about getting that. So it is correct that there will be some additional discovery as soon as we're able to bypass those devices and get to it. Third and finally, I think scheduling orders are extremely beneficial. We appreciate it, Judge, but I think we've also seen that as professionals, we can talk through issues and, where feasible, discuss whether there might need to be gentlemen and gentlewomen's agreement about certain things. And I understand that there may be a necessity to extend some deadlines at some point. So I don't generally have an opposition to some sort of extension of time for filing of motions out of fundamental fairness, in light of the fact that I do not have some things that I need to turn over to them, and it's because of the difficulty in accessing the devices.
Sounds like there shouldn't be an issue in modifying the schedule.
Thank you.
So what I'll do, though, I'll need to get back into it, and look, what I'll do is push out, most of those deadlines are connected. A lot of times those deadlines are connected because I have a trial date in mind. I don't have that at this point. So I'll push it out and see what deadlines we need to shift in order to accommodate.
Very good. Appreciate it, Your Honor.
No, just to be clear for the record, we're not doing or presenting anything today that's waiving Mr. Bryan's speedy trial right. And subject to continuing conversations with counsel, things may change, but as it stands right now, we anticipate filing a plea bar in the middle of January, which, whether we prevail upon that motion or not, intend to resolve against it.
Any other matters for the court?
Your Honor, I just need to give this to the clerk of court. It's our flash drive, Exhibit 32.
Okay, whether the court, then the last matter is the court's ruling on the motions for bond. The court heard a lot of evidence, and as indicated, I don't want to get into trying the case. And at this time, what I'm going to do, I think, is the easiest thing to move forward, is we're going to have to put a written order in place. Let's go ahead and rule and give a few, or touch on a few of the things the court heard from the evidence, and flesh it out a little bit more in the written order itself. So, that being the case, the court does not intend to grant bond as to Travis McMichael or Greg McMichael. Generally, with regard to Travis McMichael, the court had serious concerns about a number of witnesses. Again, I'm just going to touch on a couple things. There are other issues the court just needs to flesh out. At least the live witnesses, which was Travis McMichael's mother, and then two, as they described it, best friends and spouses, indicated to the court that there was a significant concern about bias. What concerned me the most, though, was the consistency of the testimony, and then what I have to comment upon the record, what I found to be an absolutely indefensible explanation from one of the witnesses in open court under oath as to an email exchange. That alone, at least with regard to that one witness, in this court's mind, placed the rest of his testimony, given the consistency of his testimony, potentially other testimony, well, indicated what the bias that exists with regard to those witnesses. As to Greg McMichael, court has some significant concerns about the fact that it does appear from the evidence that's out there that Mr. McMichael was willing to place the law in his own hands, that felt that he had the ability to influence an ongoing investigation, and I think the facts are still developing on this, but possibly was one of the reasons why this case took so long to get to where it is right now. There was a comment, I think, during the closings about how there was no risk of flight because from February to May he hadn't left. Well, I kind of see that evidence a little bit differently. To me, that's an indication that he's just not very comfortable with the calls that were made to the DA and other things. So I think that evidence cuts both ways, and in this case is a consideration for the court with regard to bond. What's interesting about the facts in this case, I agree that the transcript from the preliminary hearing is the GBI's version of facts. Cross-examination based upon the issues that were presented at the preliminary hearing itself. But more importantly in this case, there's a video. There's a video. Okay. So one can look at the video, and I don't disagree with the response I'm probably getting mentally, which is, you can interpret the video in a number of different ways. But the video, to me, tells me that there's a significant risk, threat, or danger to the community. What I saw, I understand there's no, I'll look back to make sure that, because there was some reference during closings about how Mr. Arbery had been identified from prior videos. I don't remember the evidence being that. That may have been argued, but there's nothing to indicate to me that he was known as the guy in the neighborhood prior to the David shooting, which tells me that an anonymous person was chased through the neighborhood to be detained for trespass and burglary. And that then somehow resulted in individuals believing it was appropriate to block that individual's path of travel, shoulder a firearm in order to get them to stop. There is a significant danger that all of those actions believe that the individuals that do that need to be aware of the fact that they could end up exactly where they are now. And that's not judging the evidence as to what we'll hear at trial, but simply looking at the video and taking, I think, a reasoned perspective on what we see. Then after that, the DA was called from the scene. There were a number of comments about the firearm being issued. Again, there are a number of different things that the court will place in its written order. I'm not going to get into social media. I may touch upon in the order itself. I think that focusing too much on that social media at this point takes this case in a direction that I've been trying to indicate to the lawyers I don't want to take it in. But I may have to touch upon that in the order itself. That's just an outline of where the court's going to be going with this review. And that will be entered sometime. Today's Friday, hopefully sometime early next week I'll get the written order out. Any questions from the defense on that, Travis?
Fairly shocked at not the ruling, but the reason that they didn't know who that was. So I just asked the court to look at it.
I'll look at it.
Your Honor, on behalf of Greg McMichael and perhaps on behalf of Travis McMichael, I do think the court did make some misstatements of fact. There are a lot of facts in the case, and perhaps a review of the preliminary hearing transcript and the other evidence that was admitted.
Well, I'm not going back into that. I just indicated to you that I've seen the video. I'm just pulling that as an individual looking at I understand there's concerns about the transfer.
No, I'm not trying to change the court's ruling today. I'm here to say that we'd like to submit a certificate of immediate review to you so that when you issue your written order, you may also sign that for us as well.
Appreciate the notice. I haven't drafted an order yet, so I think it's premature.
Nothing, Your Honor.
All right, those being all the matters then before the court, we are in recess.
Take care.
Thank you, Your Honor. Safe travels.